The discovery process in a DUI case is very, very important. That's the purpose of this video, is to explain to you the discovery process as we move through the litigation of a DUI offense, a DUI case in the state of Alabama. Once someone is charged with driving under the influence in the state of Alabama, a process begins. And the process for the part of the police, the court clerk, and the prosecutor is making sure that all evidence is gathered, that all paperwork is filled out completely and in the proper manner, and so that the court file is built against you as you move through the process on your way to court. The usual amount of information that we receive from someone who retains us to help defend their DUI charge is usually a certificate of breath alcohol analysis indicating a specific breath test result from the Draeger breath test device used in Alabama, or we receive a breath certificate of analysis that indicates a refusal of the test. And we would obviously ask questions of our client to determine if they actively refused the test and indicated, I am not going to take your test, or if there was some error with the machine, or if the person could just not provide a correct sample and the test was aborted by the officer or after so many times by the machine. That's the first thing we're going to look for. The second thing is what's called an AST-60, and that is an orangish yellow piece of paper that an officer generally gives to a DUI defendant after they have been arrested and their driver's license has been confiscated. And there's lots of information on the front side of that related to the arrest, and it's something that we definitely need to see and to analyze as we move through the case. The other items that we generally see from defendants include a booking report, an inventory, a tow truck report. Those are really the only items that someone usually has as it relates to a person who's been charged with DUI that comes in and retains us to help them. Most people are always after the police report. I want the police report. Have you gotten the police report? We hear that a lot. And the answer to that question is, number one, generally a prosecutor in the state of Alabama would tell you that the police report is generally not discoverable. I can tell you that most of the time we receive copies of the police report. Most prosecutors we have a relationship with, and they will send us a copy of the officer's notes, the police report, the field sobriety test notes, and we get those regularly. So as you move through the litigation of a DUI case, it's important not to get in a hurry, number one, and it's also important to make sure that the information is gathered in a way that is customary and in a way that we have done hundreds and hundreds and hundreds of times. Now, the next step in the process, once everything is set up with the court and we have been retained, is to determine, based on the information that we need and the information that our client has provided us, whether discovery motions should be filed. And there are decisions that have to be made as it relates to that. We have very specific, sometimes very lengthy discovery motions that we need to file in certain cases. Certain cases are outliers that require further investigation and further discovery motions, and those include cases where there's a blood test that was done, cases where there's an accident. There are other items that we need to send out, and sometimes we need to send out subpoenas as well. The discovery motions that we file, we are asking for very specific and certain items. The few of the things that we always ask for are statements of our client, the defendant, statements made by any witnesses, and really what we're trying to do is develop the case through information that we can receive long before the first court appearance. If we do not get those items prior to the first court appearance, it is not something that alarms us. It is just something that we have to move through the process and get over time. If a case is set for trial and we file discovery and haven't received anything and may or may not have filed a motion to compel, a failure to respond sometimes can benefit the defense of a case, but oftentimes the case would be continued. The main thing is gathering the information and working through the process in a way that we have done many times in the past. The other items that we're looking for are any results of chemical tests, whether tests of the breath, of the blood, of the urine. We're also very interested in getting the results of the standardized field sobriety tests. Now, a lot of times those are located on the police report, and we can make a very good argument that the standardized field sobriety tests are chemical tests, are tests that were performed on the defendant, rather not chemical tests. The chemical test would be breath, blood, or urine, but these are tests and examinations that were performed on our client, the defendant, and therefore we're entitled to the results of those non-chemical tests, the standardized field sobriety tests. And usually we receive those, whether it's field notes, whether it's on the whether it's in the police report that we receive a copy of. The other thing that we need to make sure that we, number one, check to see if it's available, and number two, get a copy of it if it is available, is any recordings. Video recordings, audio recordings, whether it's a video of the stop, a video of the field sobriety test, whether it's a video of the booking room. Those are all items that are very important. And also the mugshot is very important because it usually shows a lot about how a person looked at the time of their arrest, and we will compare that obviously with the officer's report to make sure that everything adds up as far as his or her analysis. We also ask for what's known as the CAD report, which is computer-aided dispatch. What that is basically shows when the officer was dispatched to the call, when they pulled someone over, and it helps us to come up with a timeline as it relates to the actual DUI process, the DUI arrest, and the officer getting to the point of making an arrest decision. It's very important that we put together a timeline because there are certain items, such as the 20-minute deprivation period, that have to be strictly adhered to, and if not, then the prosecution could have problems as it relates to introduction of the breath test and other evidence. It's also very important that we go through and obtain information about your case in a way that benefits you and your case. We could very easily file 5 to 7 to 8, 10 discovery motions on every case up front and file a motion to compel and require that we get the information in 15 days. But as we move through the case, generally we'll get the information that we need, and it's very important that we get that information in a way that benefits our client the most. I hope this has given you a great overview of the discovery process as we move through the litigation of a DUI case in the state of Alabama. If you have any questions about the discovery process, or if you have been charged with DUI in Alabama and you need help, all you have to do is call us to begin the conversation. You can reach us at 866-348-2889. You can reach us again, 866-348-2889. My name's Joseph Kreps. I'm a DUI defense attorney in the state of Alabama. We've handled thousands of DUI and related traffic offenses in the state, and we can help you. You could visit our website, www.alabama-DUI-attorney.com. That's the symbol -attorney.com. Thank you very much.